Brian Neiman, Brian Wilson, Mary Catherine Ham, today's newsmakers, and you, the Morning Majority.
6:37 on WMAL. We got Major Garrett coming up next hour from National Journal. Talk about the debates, also the State of the Union address tonight. D.C. Councilman Michael Brown joins us in the 8 o'clock hour, and Larry Kudlow also coming up at 8:36. Joe DiGenova, our legal expert, is on the line right now. Good morning, Joe.
Good morning.
We're just having a fun conversation about what happened with Senator Rand Paul with the TSA the other day. And
yes.
Some people question, where is the legal line for what the TSA can do when it comes to searches?
Well, when you go to an airport, you're basically waiving all of your rights. You accept as part of the agreement to buy an airline ticket that the government has control of access to the airplane and what happens on the airplane. And the government has the right under current law to do whatever it needs to do to safely get everybody on that plane. And the limits of this are going to take a long time to work out and maybe some litigation in the future. But right now, the government designs the access, controls the access, and makes determinations about who should or should not be getting on a plane.
All right.
We've decided that's the way it should be.
Right.
But here's my question about that, though, Joe. I mean, he said, look, the scanner goes off randomly. There was nothing wrong. I didn't have anything. I rolled up my pants leg. I showed him I didn't have anything around my knee. And yet I was detained for an hour and a half. I was yelled at for using my cell phone. Apparently they told me I couldn't use my cell phone when I was in detention. I poked my head outside the cubicle one time. I got barked at, said, you can't leave. Do they have the right to detain you in that situation?
Well,
and what are your rights in a situation like that?
Well, I think that is an interesting question and a more complex one. The right to leave should be open to all citizens, and indeed, if he was kept in a room that long and was not allowed to leave, and he says he was yelled at for using his phone, well, they didn't seize the phone, so obviously they knew he was going to use it. So there is a lot of intimidation that TA is trained to use as part of their job. However, the training at TSA is not what it should be. Detaining someone for an hour and a half is definitely actionable. You can sue in federal court over that. There's no way that's not a detention. The notion from the White House and TSA that he was not detained is ludicrous. A momentary stop under search and seizure law is considered a detention, for heaven's sakes.
Right.
If you're not free to go, you are detained.
Although, from the other side of it, if a terrorist, what's that guy is a terrorist, and he, the bells go off, and he says, no, I don't want you to do a secondary pat-down on me, and they have him detained in another room, do you want to let that guy go? Can he just get up and leave?
I can assure you, if they thought he was a terrorist, he would not have been detained for an hour and a half. He would have been moved someplace else.
Right.
They would have done a pat-down out of the view of people immediately. The truth is, these people didn't know what to do because somebody figured out who he was. And they spent an hour and a half talking to headquarters, trying to figure out what they were supposed to do, and then worked out a cover story during that hour and a half. This was just bad management, classic government bungling. He never should have been detained for an hour and a half. And if he really was detained for an hour and a half, and that's easy to prove, then he not only should he sue, he ought to, over in the House, they ought to issue some subpoenas.
Well, he was detained long enough to miss his flight. But there's other fish to fry here. We're going to talk to you about the Supreme Court yesterday and this ruling that said that law enforcement does not have the right to put a GPS tracking device on your car without a search warrant or a warrant for permission to do that. And I found the legal reasoning on that very interesting.
Well, the Justice Scalia wrote for a 9-0 majority. Let me underscore that, 9-0.
Wow.
There was no disagreement.
That hardly ever happens.
The police officers are always asking for bright line rulings. Well, they got one yesterday, and the bright line ruling was if you are going to physically go over to someone's car and affix an electronic device to it, you need a warrant to do that. That was the limited ruling that 9 justices agreed on, that attaching of that object to the car was an invasion of privacy, a violation of the expectation of privacy, and required a warrant. Now, interestingly, in this case, they had gotten a warrant to attach it, but it had run out. It was an 11-day warrant, and they installed the device on the 12th day in another jurisdiction. Now, how that happened is beyond me. That's a case management problem, but the bottom line is that it was 9-0. Now, a group of other justices concurred in the result, which was, that it was unconstitutional. but said they wanted the court to go further and deal with all of the complex electronic technological issues that were posed by the case. But they could not get an agreement on that, and so they did this one ruling that the attachment of it is enough for the moment to call unconstitutional.
Now, there's a law that's making its way through Virginia right now, and the ACLU has said that this ruling from the Supreme Court yesterday means that this bill can't go forward and that it should be killed. It basically would allow police officers to do that. It empowers the police to use devices without a warrant. Does that mean that that bill is unconstitutional?
Oh, yeah, absolutely. It's dead. If they were to enact that, it would be struck down within 24 hours.
What about the use of these GPS tracking devices, let's say, by private investigators?
Well, that area of the law has not been addressed by courts. Now that this has been ruled, it could be that those would constitute invasions of privacy like wiretapping. And how you would be able to use those in the future as a private investigator would be open to question.
And that would go state by state, my guess, right?
Yes.
Yeah. All right. What about the CIA officer charged in links, talking, I guess, to the New York Times? These are some pretty serious charges here.
Yeah, this is a 14-year veteran of the Central Intelligence Agency, a fellow named John Kiriakou. Sounds very much like Mr. Kiriarkin from the old television show. He is a former CIA officer, and he revealed the names of people involved in interrogations at Guantanamo so that their identities could be shared with detainees, and actually some of the lawyers representing the detainees appear to have gotten their names. This is very serious business. This is really a betrayal of the first order. And obviously, apparently, his defense is going to be, I didn't give it to the enemy, I gave it to the New York Times.
Right.
Well, question, is the New York... Never mind. But I mean, very, very serious matter, and apparently they got it from his emails and other electronic communications with reporters and others, and so they've got a very, very good case. And by the way, the Obama administration, for all those out there, thinking about this, has brought the largest number of leak cases in history. They have brought more leak cases against government employees than all other administrations combined.
Interesting. All right, Joe, always good to have you on. Thanks very much.
Guys.